We are pleased that Professor Tang is here to continue his examination of how overconfidence is destroying the Supreme Court and how we can fix it. Professor Tang graduated summa cum laude from Yale University, received his Juris Doctor from Stanford Law School, and now teaches at UC Davis School of Law. His articles on the court have appeared in numerous publications, including the New York Times, Washington Post, The Atlantic, and other publications. As soon as his book was published, I hurried out to purchase it and found it to be excellent. Luckily, he's here. He brought some of his books in case you want to read them, but I really encourage you. It's very interesting. He has brought a number of copies which are available to be purchased after his presentation. Please join me in welcoming back Professor Aaron Tang.
All right. How does that work? Great. Well, thank you all for taking the time to be here. Thank you to Michelle for the invitation and the introduction. I'll just start by coming right out and saying what's probably on folks' minds, which is we live in unprecedented times when it comes to today's Supreme Court. Never before in our lifetimes has the court been this unpopular, right? This distrusted by the American people. So I have two goals, maybe three. We'll start with two in our time together. The first goal is I want to talk a little bit about why I think it is the court is facing its current legitimacy crisis. The second goal is I want to talk a little bit about what it is we can do as everyday Americans to try to fix that problem, right? To fight for a court that is, again, worthy of our trust. And the third thing I want to do is talk about the current event that's probably on most people's minds, which is what on earth is the Supreme Court going to do with all these big Donald Trump cases? So I'll talk about that at the end. Okay. So, but let me start just with some receipts to show you just how much of a legitimacy crisis the Supreme Court is facing today. So ever since 1973, Gallup has asked Americans how much confidence they have in the Supreme Court. And for decades, especially in the 1980s, people answered that question pretty positively. In the 2000s, you started to see some more divides, closer to 50-50 kind of numbers. But if you fast forward to the summer of 2022, so a year and a half ago, that's the summer when the Supreme Court gutted reproductive autonomy rights, gutted common sense gun safety measures, church-state separation, environmental law, and just like a startling stretch of decisions over a month. After those rulings, things hit a tipping point. Right? In that summer, in August of that year, 2022, 3 out of every 4 Americans, 75%, reported that they had either no confidence, very little confidence, or just some confidence in the Supreme Court. And that is a problem, right? It's a problem because when people don't trust the court, the supposedly even-handed referees in our constitutional system, it's not clear why they would keep respecting the norms of our democracy, right? Why would anyone keep playing by the rules of a democratic game if they think the referees have rigged it? And so why then has trust in the Supreme Court fallen so precipitously? The usual answer that you'll hear is partisanship. And I think that is certainly a part of the problem. It's not a coincidence that public confidence in the Supreme Court has fallen, even as the justices of the Supreme Court have started voting in patterns that are pretty much indistinguishable from the political parties of the presidents who appointed them. But I think partisanship is only a partial explanation. It's incomplete. And we know that because Supreme Court justices have always been partisan. Right? For example, the court was extremely partisan for more than 30 years under the leadership of its greatest Chief Justice, a Chief Justice named John Marshall in the early 1800s. In fact, John Marshall was a longtime political operative of the Federalist Party before President John Adams appointed him. And by the way, John Adams appointed him after he had already lost the election of 1800. So in the last days as he was leaving office, he appointed John Marshall for basically the explicit purpose of doing anything he could to block the policy preferences of the incoming president, Thomas Jefferson. The Supreme Court was also very partisan after the New Deal. when FDR nominated 8 justices, remarkable 8 justices over a period of just 7 years, and all of them voted very reliably in favor of FDR and the Democratic Party's policy preferences. So if partisanship just by itself, that was enough to really torpedo public trust in the Supreme Court, we would have expected the Supreme Court to lose popularity during those very partisan periods in its history and others. But what actually happened was the opposite. Right? There's lots of evidence in those periods that the court actually increased its public standing. So what is different then about today's Supreme Court compared to the very partisan Supreme Courts of years past? I want to suggest that the answer is a basic psychological trap, a psychological bias known as overconfidence. The justices who serve on today's Supreme Court, in addition to the justices of very recent times like Antonin Scalia, Ruth Bader Ginsburg, Sacramento's own Anthony Kennedy, they are more certain than ever before that they alone, as 9 unelected lawyers, that they can solve all of society's most difficult moral and policy problems with just the right lawyer's argument. And you can see this overconfidence bias actually pretty much everywhere the Supreme Court moves. One place, of course, is in the court's opinions. All of you, I am sure, are familiar with the Supreme Court's decision in 2022 in Dobbs versus Jackson Women's Health Organization, the case that overruled Roe versus Wade. Well, writing for the majority, a 5-justice majority in Dobbs, Justice Samuel Alito, his opinion was just lathered in overconfidence, right? Roe versus Wade, another case called Planned Parenthood versus Casey that upheld the right to abortion. They weren't just honest, good faith mistakes, right? To Justice Alito and the majority, they were egregiously wrong. To Justice Alito, the reasoning that had earned the support of a bipartisan supermajority of justices in Roe and Casey, including, by the way, the votes of 9 out of 12 Republican appointees, 9 of the 12 Republican appointed justices who voted on abortion rights in those cases agreed with the right to abortion. Well, their views to Alito, they weren't reasonable. They were, quote, exceptionally weak, right? Exceptionally weak, egregiously wrong. Think about it. These aren't phrases that we use like in ordinary conversation, right? These are phrases that only the most overconfident people use. Never mind that the self-proclaimed, quote, most important historical fact that Justice Alito relied on in his opinion in Dobbs is claim that in 1868, 28 out of 37 states banned abortions throughout pregnancy. Never mind that that was actually no fact at all. Historical errors plague as many as a dozen of the states in his count. Or think about the overconfidence that characterizes, and this is always a fun topic, the Supreme Court's recent ethics scandals. Right? Think about the kind of certainty you'd have to have in your own righteousness, your own ways, to just go out there telling the American people that there's just nothing to see, no problem at all about accepting a free personal jet flight and luxury vacation from a billionaire, and then turning around and voting in that billionaire's favor on a case that's really worth hundreds of millions of dollars. Right? Think about what it would take to see no problem there, because the American people should trust you. You're, after all, a Supreme Court justice. The justices' extreme overconfidence is also obvious in their personalities. And so the book shares some stories from my time with justices from Ruth Bader Ginsburg to Antonin Scalia, where I think I'm basically just floored by their inability even to admit the slight possibility that they might not know the answers to some of the hardest questions that divide Americans. So all of that is what combines, I think, to create the problem. Right? If you had a partisan court that was more humble, like, as it turns out, the Supreme Court after the New Deal under FDR, or like the Supreme Court that was led by John Marshall in the 1800s, that's a court that would recognize the limits of its own knowledge and rule in ways that don't actively harm, or at least don't turn off, the American people. But by contrast, a Supreme Court that is hyper-confident and partisan, like today's court, well, that's a court that has no qualms about stepping all over the American people, and it shows in today's court's rulings. Okay, so what can we do about it? This is sort of shifting to the second goal of the talk. If you are someone who is worried about the future of the Supreme Court, the future of our country, as I'll admit I am at many, many moments, there are times when things can feel helpless. But I think that is a time for us to pause and maybe look back to history. Right? It's often the case that if we look to history, we can chart a path forward that is potentially more promising and that can lead to a brighter future. So the history that I'm thinking about, and I'd like to talk with you about today, starts in the early 1900s. This is a time when actually a similarly overconfident Supreme Court is issuing decision after decision that was overturning the will of a majority of the American people. It turns out at this time in the 1900s, the main issues are economic issues. They involve questions like, can Congress or can a state ban child labor? Can Congress or a state guarantee workers the right to unionize? Can they pass a law guaranteeing a minimum wage? Most Americans thought the answers to these questions were yes, but a majority of the justices on the Supreme Court said no. In case after case, struck down minimum wage laws, child labor regulations, and so forth. Well, as you all know, if you fast forward a couple decades, a largely underregulated economy leads to the Great Depression. Americans respond by voting FDR into office, his promise of a New Deal, right? The idea that greater economic regulation, greater government spending can help kickstart the economy and protect workers from the excesses of capitalism. And yet, when Congress passes these New Deal laws at first, the Supreme Court strikes them down too, right? Based on little more than 5 very conservative, economically conservative justices, based on their self-assured belief that they know better than the American people, than elected lawmakers. They know better how to run an economy. So what did the American people do, right? When we were faced with this overconfident set of justices in the majority of the Supreme Court who were out of touch with what the people wanted, I want to highlight 3 responses, all of which it turns out are available to us today. Okay, so the first thing is people voted. People voted en masse against the Supreme Court and the anti-regulatory views that it stood for. Right? So in the election of 1936, right after the Supreme Court struck down a bunch of very popular New Deal laws, the American people reelected FDR with 60% of the popular vote and gave him huge supermajorities, Democrats, in the House and the Senate. But here's the second thing. This is different. This is harder even than winning elections. After Democrats won elections, they didn't just turn around and go right back to their home districts and start raising money and running for re-election. They actually got to work. They passed actual laws. In particular, right, so this newly elected Congress, and this is a little bit, it's interesting to think about. They passed laws that were nearly identical to the exact laws that the Supreme Court had just struck down the year before. They reenacted major agricultural regulations, industrial regulations, and they basically said to the Supreme Court, do it again and see what happens, right? Forcing the court to seriously reconsider what it had just done. And the third thing, you all are familiar with this, I'm sure, FDR threatened the court directly, right? He proposed a bill that would add as many as 6 additional liberal justices to the court. And as you all know, that plan failed in the sense that the Congress did not actually pack the court with 6 more justices. But if you stop and think about it, the plan actually did succeed in a different kind of way. Right? Combined with the landslide election results in 1936, Congress passing these new laws that forced the Supreme Court's hand, the effect of the court packing proposal was to put enormous pressure on the conservative justices then on the court to back down. And that is exactly what happened. 2 of the 6 conservative justices then on the court, so Chief Justice Charles Evans Hughes and Justice Owen Roberts, switched their votes in a pair of major cases in 1937. This is what led to the saying, the famous quip about the switch in time that saved 9, being 9 the number of justices on the Supreme Court rather than 15. They switched their votes and they never looked back. Right? Instead of being conservative justices on a delegitimized and maybe even a packed Supreme Court, right? Chief Justice Hughes, Justice Roberts decided they would rather be moderate justices on a centrist Supreme Court. But what's really important is how they did this, right? They didn't just write, we're changing because, it's politically unpopular now to be conservative and we're just flopping in the wind. They did something very different. They embraced a much humbler role for the Supreme Court, and a much humbler role for what it would mean for them to be Supreme Court justices, right? Rather than acting like they alone, Supreme Court justices, that they alone could discover the single best answers on all these hard economic policy questions, Hughes and Roberts decided that they would trust the judgment of other people, and particularly the judgment of elected officials. So they began deferring to Congress and states when they enacted these economic regulations. Okay, so if you fast forward today, if you want to be just a little bit optimistic, not too optimistic, but a little bit hopeful about the court's future and the country's future in this difficult moment, here are some reason for maybe just a glimmer of optimism. It is possible that maybe, just maybe, the public's anger at the Supreme Court over its rightward lurching term in 2022, that maybe that has had some effect. So let me tell you about a couple surprises over the past year. So the biggest surprise is in a case called Moore versus Harper. This is from last summer. It's a case in which Republican lawmakers in North Carolina tried to defend their act of drawing up partisan gerrymandered maps that would lock in Republican seats in the House and the state legislature, using a legal argument called the independent state legislature theory. You might remember that from the news about a year ago. At its worst, that is a theory that could have opened the door to state legislatures overriding the legitimate results of statewide presidential elections and swinging their state's electoral votes to whichever candidate they prefer, which is something we now know Donald Trump openly advocated in the 2020 election and that he's now been indicted for. The Supreme Court rejected that extreme version of the independent state legislature theory. It held in an opinion written by Chief Justice Roberts, joined by the three liberals and Justice Brett Kavanaugh and Amy Coney Barrett, that state legislatures are not independent in the sense that they do have to follow state constitutions. They have to follow state Supreme Court rulings. And when those Supreme Court decisions block partisan gerrymandering, that's the end of the story. The court seems also likely to surprise progressives in a very good way in a big gun case this year. So the court held oral argument in this case in the fall, and the justices seem very likely to reject a sort of almost unbelievable argument by gun rights advocates that the Second Amendment forbids Congress to pass a law disarming domestic violence abusers. Right, taking guns away from them. There's an argument, a very serious argument. The Fifth Circuit Court of Appeals said that, yeah, the Second Amendment protects the right of domestic violence abusers to have a gun. Well, at oral argument, not even Justice Clarence Thomas seemed ready to defend that kind of an outcome. So that's some reason for maybe some cautious optimism. I don't want to be naive here. I don't want to suggest that the Supreme Court is like magically left-leaning or even centrist. Right, the court during this time also invalidated President Biden's loan forgiveness plan in a decision that really hurt millions of student loan borrowers. The court opened a very dangerous door to discrimination against the LGBTQ community last summer in a case out of Colorado. And of course, it overturned a decades-old precedent allowing colleges to consider race as one factor among many in higher education admissions. We can talk about any of those cases if folks are interested. For now, the point is I want to recognize that the Supreme Court we've got, it's never going to magically become a truly centrist. But I do think there's some reason to think that when the public expresses its anger at the Supreme Court, like we have over the past year and a half, at least some of the more institutionalist of the conservative justices can get cold feet. And it affects how far right they are willing to go in at least some cases. Now you might say, well, gosh, that's still a pretty small consolation prize, right? Is it really true that when we, the American people, we get angry, we mobilize, we protest cases like Dobbs, we rail against the court, that the best we can hope for is like a few breadcrumbs, a few modest rulings every June? And I think that's a legitimate concern. So I think what it suggests is that Americans, what we really need to do, right, we really need to fight for it. We need to keep demanding, talking about structural court reform, maybe even court packing, until we get is a sign that this court is not just handing out the occasional moderate or progressive decision, but rather that it is changing how it approaches hard cases that divide our society. We need, in other words, as a Supreme Court that recommits itself to a humbler view of its role, much like Justices Owen Roberts and Charles Evan Hughes did in 1937. But there's another problem, right? So in 1937, the court's answer to the overconfidence problem it had then was to humbly defer, right? To trust elected lawmakers, let them decide hard questions like the minimum wage and child labor regulations. And that worked when economic issues were the biggest issues of the day. The problem, though, is that legislative majorities can do some really bad things, too. Right? Just think about how racist majorities throughout our sordid history have enacted segregation laws, condoned outright racial violence. In other words, sometimes the Supreme Court actually has to intervene against legislative majorities rather than just trusting them or deferring that to them. And if you think about it, if you just want to pause for a second, that is it. That's the pickle that we face today at the Supreme Court, right? The very theories of constitutional law that allowed the Supreme Court in 1954 in Brown versus Board of Education and a series of decisions after that to feel emboldened enough to strike down segregation, discrimination laws as violating the single correct meaning of the Constitution. Once that can was open, right, those are the same theories that have emboldened the Supreme Court today to turn around and strike down the laws that these justices don't like. And so it seems like we're maybe stuck, right, between a rock and a hard place, right? The rock is that maybe we have a Supreme Court, like today's Supreme Court, that just overconfidently declares the law, remakes the law in its image everywhere it goes. That's one option, an overconfident court. But we might worry that the other option is an emasculated Supreme Court, one that defers, trusts elected lawmakers with whatever they do, even if the lawmakers are tyrannical or discriminatory. So I want to suggest that there's another way. This is sort of the last topic from the book that I'll talk about. I'll touch on before I stop for questions. Quietly, almost by accident, but in a surprising number of cases, the Supreme Court has sometimes employed an effective approach, a good way of deciding these big, hard cases that divide society. And sometimes, rather than boldly announcing what the justices think the right answer is based on, obscure lawyers' arguments, sometimes the court candidly admits that the questions before it are hard. And it candidly admits that both sides have reasonable arguments, and there are really big stakes on both sides. And then in some of these cases, the court does something very wise. It rules in the way that tries to do the least harm possible. Right? It tries to rule in the way that ensures that whoever loses in the Supreme Court has the best possible options for still protecting its interests outside the court. So I call this approach the least harm principle in the book. I describe a bunch of cases where the Supreme Court followed it with pretty good success. Cases like the Nixon's tapes case, a tough case about the right to die, a range of others. I'm going to give an example from 2020 in a case involving Donald Trump to try to illustrate how this least harm approach works, how the Supreme Court tries to rule against the side that has the best options for protecting itself even after it loses. Okay, after we do that, we'll talk a little bit about what this approach might look like in the two big Trump cases in the Supreme Court today. All right, so in 2020, prosecutors in the state of New York were launching an investigation into accusations of criminal wrongdoing by the Trump Organization and its affiliates. To complete that investigation, they needed a bunch of information. They needed private financial information that was being held by Donald Trump's banks and his accountants. And so New York prosecutors did what they would do to anybody who was in possession of information that could reveal criminal wrongdoing. They issued subpoenas to get the information. Donald Trump, unsurprisingly, sued to block the subpoenas to make sure the state courts couldn't get access to his financial records. And that's a case that made it all the way up to the Supreme Court in the summer of 2020. Remarkably, the Supreme Court ruled against Donald Trump in a bipartisan 7-2 vote, an opinion written by Chief Justice Roberts, joined by what was then 4 liberals, plus Justices Kavanaugh and Gorsuch, both of whom Donald Trump appointed. And the most important thing about the ruling is how the court explained or how it reached this result. The court did not pretend like the question of whether states should be allowed to subpoena a sitting president was somehow magically answered by the text of the Constitution or history or tradition or common law or even, evolving societal values or precedent. The court instead asked this sort of wise question I've been describing. Gosh, this is a hard case. If we get it wrong, which side would be able to fix that mistake more easily? Which side would be able to better avoid the resulting harm? Donald Trump or the state of New York? And then the court reasoned that actually Donald Trump had lots of other options if the court were to rule against him, right? Donald Trump had lots of ways to protect from his harm, which is he was worried about a bunch of states issuing burdensome, bad faith subpoenas that were trying to harass him. And the Supreme Court said, well, actually, Donald Trump, you already have a bunch of defenses. State law already provides Donald Trump, like you and me, a legal argument, legal defense that if a prosecutor is subpoenaing information from you in bad faith, the state courts will block those subpoenas. So the Supreme Court didn't need to invent some new constitutional rule to protect him. But by contrast, the court reasoned it recognized that if New York that didn't have access to this information, there would be criminal violations that would go undetected. And so it ruled for New York. Right. And true enough, all of those records revealed severe acts of financial impropriety that led to an indictment against Trump CFO Alan Weisselberg, who eventually served a jail term because of it. But here's the really interesting thing. After the Supreme Court issued this big blockbuster ruling against Donald Trump, nobody was all that upset. Right? Even Donald Trump was muted. He went on Twitter, X, whatever it was. He actually said that, the Supreme Court, it's really just sending this case back to the lower courts for more arguments. No big deal, nothing to see here. Not coincidentally, the Supreme Court's public standing benefited too. Right? The court applied actually the same least harm approach to several cases in that summer of 2020. And afterwards, and this is almost hard to believe, hard to remember, because it's during the heart of the pandemic, everybody's upset about everything, except it turns out the Supreme Court. 58% of Americans, a majority of Democrats, moderates, Republicans, all approved of the work the Supreme Court was doing because the court was making sure that whoever lost in these big cases had other arguments, other things they could do to protect themselves. It's a record number that's obviously since fallen off the cliff as the Supreme Court has gotten more and more overconfident. Okay, so I want to talk for the last few minutes here about what it would look like if the Supreme Court would take the same approach, as I think it might, the same least harm principle, to decide the two big Trump cases that are currently in the Supreme Court and currently in the news. Okay, so Donald Trump has asked the Supreme Court to intervene, to rule in his favor on two big issues. The first issue has to do with a ruling that was issued last December by the Colorado Supreme Court, effectively taking Donald Trump off the Colorado presidential primary ballot for the Republican Party. And the Supreme Court of Colorado's reasoning was that actually Donald Trump is disqualified from becoming president, from holding office, under a constitutional provision that nobody knew about until like a minute ago, which is Section 3 of the 14th Amendment. Right? Section 3 of the 14th Amendment disqualifies certain office holders from holding certain offices if they have, quote, engaged in an insurrection. So the Colorado Supreme Court said January 6th qualifies. Trump engaged in it. Right? He can't be president. We're taking him off the state's ballot. So that case was argued in the Supreme Court earlier this month. Actually, a good friend of mine argued the case on behalf of the challengers to Donald Trump in his first Supreme Court argument, and I'm sorry to say it went very poorly for him. It was a really good day for Donald Trump's lawyers. Even two of the liberal justices, Justice Elena Kagan, Justice Ketanji Brown Jackson, seemed to be leaning in favor of putting Donald Trump back on the ballot. So I won't pretend to be, happy about that outcome from a sort of personal policy preference or political perspective. But I will say that that is probably the right answer if you think about this from the perspective of how can the Supreme Court do the least harm possible, right? And the first reason to think about that is this is actually a really hard question, right? The question is whether a 150-year-old constitutional provision that people haven't thought about, literally haven't thought about for 150 years, it was enacted in the aftermath of the Civil War, whether that can be used by states to disqualify any office holder from seeking a federal election, federal office like the presidency, based on the state's view that they engaged in an insurrection. That's a really hard question. Legal scholars, historians have argued about it. There's good arguments on both sides. It's hard. And so a court that is conscious of its own limitations, that's worried about what happens if it gets this big issue wrong, would recognize that it's hard, and it would recognize that there are real harms if this court rules wrongly against Donald Trump. If it takes him off the ballot and it deprives millions of Americans of the ability to vote for him, right, what could happen? How else will those Americans register their anger, their frustration at being what they will view as being disfranchised? Will they resort to violence in the streets? Will states like Texas retaliate by taking Joe Biden off the ballot based on their certainly misguided, but their views that Joe Biden has engaged in insurrections in various ways? Right? By contrast, if the Supreme Court acknowledges that the case is hard and rules in favor of Trump, leaves him on the ballot, right? His opponents still have one very obvious way of remedying and avoiding our harms, which is we can beat him at the ballot box. Right? We can mobilize our neighbors to get out there and vote. Now, I'll admit I'm probably as worried as the next person about what the polls look like on that question. But here's the thing. the same least harm principle, if the Supreme Court were to apply it in the other big Trump case, this is the case involving his criminal prosecution based on his actions leading up to January 6th, that is actually a decision, a case that could increase the odds of Donald Trump losing the presidential election. And that's because if Donald Trump is allowed to, if he's allowed to be prosecuted and he's convicted, large numbers of Republicans have even reported that they will not vote for him in November. So that means the question whether Donald Trump is immune from criminal prosecution, this is the other big issue that's now pending before the Supreme Court, that will have a big impact on the election as well. And that is an issue on which the least harm principle cuts very strongly against Donald Trump. Because that's, think about it this way. If the court wrongly rules against Donald Trump, imagine there is such a thing as absolute immunity for presidents from criminal prosecution. I'm doubtful of that, but it's a big question. It's very hard. You can think of situations where you wouldn't want somebody to be able to prosecute Joe Biden for something he does in good faith, but that might, arguably violate criminal law. If the court rules against Trump, think about what he can still do. He has two huge ways that he can avoid his harm being a jail sentence, right? One, he can persuade just needs to persuade one of 12 jurors that he's not guilty of the charges against him. And even if he's convicted, he can still make his case to voters, because if voters choose to put him in office, he will presumably pardon himself of these charges and escape criminal prosecution. Now, again, I think that's unlikely based on what the poll data indicates, but the Supreme Court should be cognizant of the fact that ruling against Trump and allowing him to go to trial will leave him with options. Think about how out of luck we will all be. The Supreme Court says that presidents can violate the law. They can commit crimes. They can assassinate a political rival, as was suggested by Trump's lawyer at oral argument, and not be criminally prosecuted for it. That's a world I don't think any of us want to live in. So the point of all of this is to suggest that the best way that the Supreme Court has for earning the public's trust, for protecting our democracy, the best way is for it to stop thinking of itself as this divine oracle that can discover the one and only right answer to every hard question that plagues America. And my hope is that with enough public pressure, with enough serious discussion of court reform, with enough people voting in numbers, that this court will get that message. And the message is that what America needs right now, it isn't a liberal court, it's not a conservative court, certainly not a packed court, it's a humbler court. It's a court that realizes it doesn't have all the answers, and that therefore tries to do the least harm possible. That would be a court that reminds us, the American people, that when the Supreme Court decides a case against us, we still have real options for protecting ourselves. Because when it comes to the hardest issues of the day, to protecting our endangered democracy, we are the ones we've been waiting for, not 9 unelected justices on the Supreme Court. All right, I'll stop and take questions now, and I will stick around. I will note I have a box of books here. If you're interested, if this talk has been interesting, I'm able to offer you a big discount on the book. The cover price was $30. I can sell it for half off today, so $15. So I'll stick around after the talk, but I look forward to your questions.
Okay. I'm gonna start with one question from the Zoom audience. And the question, I'll just read it. Does Justice Alito's recent criticism of Obergefell versus Hodges foreshadow a conservative attack on the right of contraception and other personal rights?
Yeah, so if you've been following the news, Justice Alito, before him, Justice Thomas, in Justice Thomas's concurring opinion to Dobbs, the abortion case, they have been quite vocal that they are not done. They are not happy with overruling Roe versus Wade, overruling affirmative action. They would like to go further. They would like to overrule Obergefell versus Hodges. This is the same-sex marriage equality decision from 2015. They potentially like to roll back the right to contraception. That's from Griswold versus Connecticut in the 1960s. So the question asks, does this foreshadow like a broader movement on the Supreme Court? It does foreshadow 2 justices. But again, I don't want to be unduly optimistic, but this is a situation where we should be thinking about the dogs that aren't barking. And those dogs are Neil Gorsuch, Amy Coney Barrett, and Brett Kavanaugh. None of the 3 of them have joined these opinions, these new decisions, criticizing same-sex marriage, criticizing the right to contraception. They've been remarkably silent about it. And so I think for that reason alone, I would be surprised if in the near term, the Supreme Court is coming for marriage equality or contraception. It's coming for many other things. Don't get me wrong. It's coming for gun safety measures. It's coming for environmental law. It's coming for the administrative state generally. And those things are worrisome enough, but maybe not these other personal liberties.
Hi, this path to humility that you're referring to, it seems to me an easy a route would be some ethics oversight. There seemed to be some attention on some kind of ethics committee a while back for the Supreme Court, but it didn't go anywhere. What mechanisms are there in place to enforce ethics among the Supreme Court?
Yeah. So I'm so sympathetic to the question because it's just such a bad look for the Supreme Court to have done what it's done. Every week over the summer, there's a news story about Justice Thomas, Justice Alito accepting this favor, that favor. I actually think, though, that was a bit of a distraction. And it was a distraction in the following sense. Suppose Samuel Alito and Clarence Thomas were hermits. They accepted no gifts, right? They did the right thing. They just sat in their offices and they read. And the Supreme Court did the same exact thing. It overruled the right to abortion. It obliterated New York, California, their rights to regulate gun possession in public. Would we suddenly think to ourselves, gosh, those are reasonable decisions. We trust that Supreme Court, right? I don't think so. I think we need to focus on the merits, the substance of what the Supreme Court's doing. And the proof of that is actually 2 months ago now, the Supreme Court, in a statement on its own website, issued a 20-page document promulgating a new code of conduct to apply to the Supreme Court justices themselves. The very thing that Fixed the Court, one of the largest advocacy organizations on this front, was demanding, right? Ethics oversight, an actual policy detailing what it is Supreme Court justices can and can't do. That policy looked virtually identical to the judicial code of conduct that is already applied and has for decades applied to lower court judges. And it barely registered in the public. And the reason it barely registered in the public is the one thing that was different about the Supreme Court Code of Conduct versus the lower court's Code of Conduct, which is the question wisely asked about, the enforcement mechanism. There's an enforcement mechanism for lower court judges. If you do something that really reflects poorly on the propriety of the federal judiciary, a panel of your peers, Supreme Court justices, will sit in judgment of you and will issue a sanction, a reprimand, can even take you off cases. That's a real deterrent. Who is going to sit in judgment of the Supreme Court? They're not going to sit. I mean, we should be wary of a world in which the justices sit in judgment of each other, because whoever's in power is going to adjudicate whoever's not in power a certain way. We should be skeptical of lower court judges who kowtow oftentimes to the Supreme Court justices, that they will hold them meaningfully accountable. And so the only real accountability we're ever going to have is political accountability. Congress, the Senate would need to take action, including up to potentially impeachment. And counting on Congress to do anything functional at this point in time seems pretty unlikely. So I don't think, unfortunately, that ethics codes are our path to salvation. I do think that continued public criticism of the court has and could continue to get some of the conservative justices to moderate some.
So as much as I think Trump committed insurrection, I think that maybe that amendment is really dangerous because that is the way other countries keep the opposition from running for office. And I wonder if you'd comment on that.
Yeah, it's so hard, right? We are all motivated consciously, subconsciously by a certain desire to see the world away, right? I have a 5-year-old daughter, and I don't want to have to explain to her, I have an 8-year-old son too. I don't want to have to explain to them why, for most of their life now, if Donald Trump wins office, we will be saying that the leader of our country is a morally depraved individual that they should be ashamed of as the leader of our country. That is a very hard thing to stomach. And so a part of me wants to say, any means necessary, keep him off the ballot, whatever it takes. But I am sympathetic also. And I think in the final analysis, in my sanest moments, I think I come down and I agree with you, which is this is not the way. This is not the way to beat Donald Trump. taking them off the ballot, sending this message to millions of disaffected voters in rural Appalachia, right around the country, that they don't even get to vote. They don't even get to choice to pick this person that for whatever reason they believe in. That is a message that can boomerang back and really hurt us, right? You've already seen the Attorney General of Texas threaten, or the Lieutenant Governor, I think Dan Patrick, threaten to use Section 3 to disqualify Joe Biden on the theory that his negligence on the border has allowed an invasion that counts as an insurrection, right? I think these are frivolous arguments, but they're not frivolous to Texans. And if Texas goes here, right, think about the door that opens. So I think the solution, the antidote to one person trying to upend our democracy is more and better democracy, rather than the opposite.
Yes, hi, thank you. So your thesis is that we need to have a court institutionally that is modest in the way it approaches complex issues. I have a specific example related to the abortion decisions that I'd be curious as to how you would square the circle. So in the Dodd decision, Chief Justice Roberts did not invalidate the right to privacy. He had a middle ground that was not sufficient to hold the court. That means there's at least 4 justices currently who have no issue at all with the notion that abortion is protected under the Constitution. Joe Biden is currently president. If one of the more conservative justices were to drop dead tomorrow and Joe Biden appointed someone who is a progressive, would it be institutionally prudent for the court to immediately reevaluate Dodd?
So I think the answer is yes. And I think your description of Chief Justice Roberts's opinion is what's so important. If you could identify one member of the Supreme Court who is a least harm justice right now, it is John Roberts. He's a man who is deeply conservative, personally, politically, in his bones. He is like the old school, real conservative. And yet he writes this remarkable opinion that is, it's like if I were to teach the least harm principle, I would just assign that opinion. Because he says, gosh, the right to abortion. For his entire life, he's been opposed to the right to abortion. He went to law school where overruling Roe versus Wade was an article of faith. There's no doubt in my mind that he would love to overrule Roe versus Wade and do everything Sam Alito says. But he says in this opinion, and it's remarkable, I'm not nearly as confident as my brethren in the majority, Sam Alito, that there is no right to abortion, that women don't have a right to privacy that includes the ability to determine whether to carry a child to term. I'm also not so confident as the 3 liberal justices in dissent that that right extends to 24 weeks, the viability line that Roe drew. So he says, here's what I would do. I would pick a different line. I would pick a line where even if I'm wrong, the people who are injured, and I'll describe those people in a moment, still have options. I would set the line, the limit at 15 weeks, which happens to correspond with history and tradition. For most of Western civilization, there has been this understanding that abortion is permissible up to the moment of quickening, the first noticeable movement of the fetus, which is around 15, 16 weeks. And Chief Justice Roberts says, if we were to curtail the right to abortion, take it from 24 weeks to 15 weeks, that's going to hurt pregnant people. 9 weeks less of a chance to use the right to choose. And they're going to be, frankly, very upset. But think about the options they have. Some percentage of people who have abortions after 15 weeks have elective abortions. That's a phrase that is controversial, but they're abortions where basically people choose to have the procedure at 16, 17 weeks. Those people would still have the ability to choose. They could have the ability to choose an abortion. They'd have to decide earlier. For individuals who are having abortions after 15 weeks for life-threatening reasons, medical reasons, most states, not every state, but most states have exceptions for severe congenital abnormalities, right? This is an argument the chief is making that if I get it wrong and I take the right to abortion away from some people, at least they have options. Now, you might say, well, what about the right to life folks, right? They're going to be upset now that abortion is still a right up to 15 weeks. What options do they have? The chief didn't say this. I don't think he needed to. But the truth of the matter is, those folks have options too. It turns out that banning abortion, criminally punishing, using the power of the carceral state to put people in jail for providing an abortion, does not actually really move the needle in terms of reducing abortion access. Depending on the study you look at over the past year and a half, we're talking about maybe a 6% decline in abortions per year in the United States. If you really wanted, if someone was pro-life and really wanted to reduce the number of abortions, there are two policy changes that have been universally shown to have a much bigger impact. The first is universal contraception, which is popular to 96% of Americans. If you provide contraception to any person of childbearing age who wants it, turns out there's studies showing that 50 to 70% of abortions are reduced because there are just fewer unwanted pregnancies. And the other option is providing real meaningful child support, family support, basic income support, childcare, healthcare, so that actually taking a child, bringing a child to term is doable. It's livable, right? Think about the impossible choice facing a working class family who's already got 3 kids in the middle of America. Parents are working 2 jobs. The idea of bringing a 4th child in looks much different if you've got a year of paid leave guaranteed by Congress, like we do in most developed countries. So there's evidence that greater welfare policies reduce abortion rates from 10 to 20% in states that embrace them. So those are the options that would be available to the other side.
So I would like to first compliment you for the succinctness and intelligence of your remarks. I've never heard someone speak so eloquently about these complex issues in such a short period of time, because I've tried myself. But I also have a question that has to do with the origins, possibly for the individual Supreme Court justices, of this overconfidence that they display. And tell me if I'm wrong. I would say it emanates from a greater degree of religious orthodoxy than we have had among Supreme Court justices. So if you have a view of theology, of the revealed truth of whatever your faith system happens to be, it doesn't leave room for pragmatism or compromise or empathy. If it's God's will, it's God's will. Is that what is motivating the Supreme Court?
I think it is a factor. I think it is partly a symptom of other things that are broken too, rather than the leading cause of its own. But I think it's definitely a factor, right? It's not an accident that 6 of the 9 Supreme Court justices are practicing Catholics. One of them is Justice Sotomayor, but 5 others being all the conservatives except Neil Gorsuch, who was raised Catholic and is now Episcopalian, so cousins maybe. It's not an accident, but I don't think that religious orthodoxy, if you will, is leading there to be more Catholics on the Supreme Court, so much as the great realignment in American political life, the broader demographic trends, the disaffiliation of, frankly, liberals moving away from organized religion, but the maintenance of association with organized religion on the right, is leading to a situation where when you combine that with partisanship, when you combine that with originalism, an approach to interpreting the Constitution rooted in the 18th century, all of those things create a situation where the people who get nominated to serve on the Supreme Court believe as an article of faith that you have to overturn Roe versus Wade, right? And those folks happen to also be religiously affiliated. So you have a lot of overlapping reasons, and none of which is to say that you're wrong. It's a part of the puzzle for sure.
I'll ask a question from the Zoom audience and try and paraphrase this, that they want to know if you think that the justices want the states to have more power relative to the federal government. Is this what's driving it?
I want to suggest that federalism, the idea that states ought to have power to make basic decisions rather than the federal government, is a excuse for justices to make decisions at the Supreme Court rather than a reason, right? So we should often, and this is true of the Supreme Court, it's true of ourselves, it's true of my kids, we should be thinking about the reason why people do things. There are reasons and excuses, right? For the Supreme Court, the reason why they overturned Roe versus Wade is their belief, 5 justices' belief, that life begins from the moment of conception, that Roe versus Wade is a horrible decision that is, resulted in the death of millions of unborn babies, right? That is the reason. The excuse is federalism. Let's let states decide, right? But we know this is an excuse and not a reason, because if the conservative justices really cared about the idea of states as laboratories of democracy, letting states take the first crack at hard policy issues on abortion, they would think that states should have the ability to take the lead and issue policy decisions on things like guns too. All of a sudden, though, on guns, states, California, New York, they should have no leeway. The Second Amendment, as understood in 1787, 100 years before the light bulb, that's what ought to control, not states, right? So I think states' rights is a excuse, not a reason.
Starting in late 1967, for a period of slightly over 25 years, every single Supreme Court justice was appointed by a Republican president. And since that time, 56 years ago, only 5 out of 20 have been appointed by Democrats. I wonder if you'd like to comment on that.
Yeah, so that seems broken, doesn't it? It's especially broken when you think about the undemographic nature of the Electoral College and our Senate, right? Because it's not just that Republicans are appointing presidents, it's that Republicans who are losing the national popular vote, right? Donald Trump lost the national popular vote. He picked 3, right? Yeah, he lost twice, but he lost in 2016. Most importantly, he lost in 2016 when he became the president. When he nominated Brett Kavanaugh, and Brett Kavanaugh was confirmed with the votes of 51 senators. Those 51 senators represented, I think, 43 million fewer Americans than the 49 senators who voted against him, right? So the hardwired United States Constitution is deeply anti-democratic. And this is one of the ways in which the harms of that anti-democratic nature manifests itself. That's the problem. I hate to tell you there's no solution, right? There's no realistic solution. If we were designing a constitution from the ground up, none of us would have a system where justices can sit for 30 years on the bench and retire whenever they want, right? And game the system. We'd have term limits. I think we'd all agree they'd be something like 18 years. You'd have it structured that so whoever wins the presidential election gets to pick 2 seats no matter what. That way there's a relationship between the outcome of elections and who's on the Supreme Court. And those are things that we should probably be fighting for. They're not going to happen because the Senate isn't going to, if the Senate gets rid of the filibuster, there are a lot of things I'd put ahead of term limits on the Supreme Court for the Senate to be doing. They won't happen, unfortunately. So the system's broken. We need to be thinking about things that we can do that are more achievable. And we can talk about those later. I put some other things on the list.
One of the recent decisions for California was surprisingly about livestock. It was Proposition 12. And the Proposition 12 in California, if we're buying meat or food, eggs and so forth here, it has to be raised in a certain way. The pens can't be too small. But Proposition 12 said the meat and eggs that come into California, they have to be raised in the same way or they can't sell the products in California. And the Supreme Court let that stand, which is surprising. It's a little different than some of the other things you're talking about. I wonder if you comment on that, because it's getting into how they grow food outside of California for us to purchase in California.
Yeah, so if you're interested in this case, this is a case called Pork Producers Council versus Ross. There's actually a very excellent description of it, a sort of cross-partisan alignment, very confusing, splintered opinions. Basically, 5 justices ruled for the state of California that they can regulate pork production in a way that exerts a pretty onerous burden on other states and pork producers in other states. So this is an ostensibly progressive outcome. I think if we're being honest about it, this is not a super politically salient issue. It matters, right, for climate change, and it matters for the humane treatment of animals for sure. But voters are probably not voting in presidential elections or national elections based on pork producers versus Ross. So you could maybe chalk this up to an issue where some of the conservative justices, Neil Gorsuch, who writes the opinion siding with California, they think they're throwing a bone to progressives on an issue they don't much care about.
Well, I think we're just about out of time unless somebody has a really short question. No short question. Oh, there's one. Let's try it. Short question, short answer.
What do you think about John Oliver's proposal to Justice Thomas, and if you sat on the Supreme Court, would you take it?
I think it's hilarious. I don't think there's any chance it'll happen. It's probably not enforceable, like not a binding contract. There are ways around it. There's been like surprising discussion of it on like law professor listservs. I think I'll leave it at that.
All right, well, thank you very much. This is great. We have just a few more. So we can get this back on. Michelle, you gonna wrap it up?
Thank you very much. I know that everybody here was just really looking forward to your presentation. And maybe if you write another book, we'll have another topic. It was very kind of you to come. I know you're busy. I just want to say that, I take off my glasses. I can't read. Join us next week, March 1st, Dr. John Grayson on psychedelics in medicine, past, present, and the future. Thank you very much for coming. You want to get there? Yeah. Let me help you.